Donald Trump's defense team blasts Jack Smith. Jack Smith doesn't want Donald Trump to be able to talk all that much. Every time Donald Trump talks, he posts a tweet or a truth or something. Jack Smith gets a little bit nervous because the scam prosecution slowly starts to unravel. And so they want to gag Trump. They don't want him to talk about this stuff. And so they submitted a gag order request. We've already gone through that filing, but now Donald Trump has responded to it. And we're going to go through this in detail because the defense team is not happy about what they're seeing coming out of Jack Smith's office. They say the basis, the claim for the gag order is entirely meritless, and that Jack Smith is trying to impinge upon Donald Trump's First Amendment rights, as he is. And of course, this is in the District of Columbia. This is out of Judge Chutkan's courtroom. So we'll see what she has to say about all of this. We already know what her position is on things like, you know, reviewing discovery, and not too concerned about whether Trump has enough time to read multiple Washington monuments full of evidence, but we'll get to that, I'm sure. This is 25 pages, and this one comes from President Trump. It's Trump's response in opposition to Jack Smith's motion for prior restraints. So saying Trump is gagged, he is being restrained from being able to communicate, and it's the restraint is being put upon him before he even speaks. It's a prior restraint. He didn't say something and then now they're saying, you know, undo that bad thing you said. It's saying you can't talk in the future. You are gagged from speaking about the future activity. So Trump's team responds, Your Honor, Judge Chutkan, we respectfully submit this motion in opposition to the government's motion to impose an unconstitutional prior restraint on Trump's political speech. On August 1st, Jack Smith, Your Honor, publicly released a 45-page speaking indictment, which is a phrase that means that they're just talking a lot of garbage in layman's terms, but they're not actually charging anything, all right? They're just talking, you did this and you did this and there's a bunch of crap in here, blah, blah, criminal, criminal, criminal. And you're like, oh, really? Is it so bad? Where are the charges? And then the charges are, you know, kind of not really related to everything else. Like they want to smear you and then charge you with just a couple things that aren't really related to the other conduct that they've discussed. So they say it read very much like a campaign press release. It was very superfluous. We don't need all that extra garbage in there. As if the indictment's media talking points were not enough, Jack Smith then went out and held a press conference to deliver an incendiary attack upon President Trump, falsely claiming that Trump did the following. Jack Smith's words: Trump fueled an unprecedented assault on the seat of American democracy. The inflammatory rhetoric, Your Honor, which violated long-standing rules of prosecutorial ethics, was then repeated daily by the media because they're just copy-paste morons all across the country. Following these efforts to poison President Trump's defense, the prosecution now asks this court to take the extraordinary step of stripping Donald Trump, the president, of his First Amendment freedoms during the most important months of his campaign against President Biden. You're saying Trump wants to poison the well, Your Honor, but your prosecutor poisoned the well. He's the person who, after the indictment came out, started speaking first. So the court should reject this transparent gamesmanship and deny Jack Smith's motions entirely. Trump's team gives us an introduction. For hundreds of years, Your Honor, our country has embraced the core value that, quote, the government has no power to restrict expression because of its message, because of its ideas, its subject matter, or its content. The government can't limit the interior of the message, right? They can't talk about that idea is acceptable, but this idea is not. This subject matter is allowed, but that is not. The freedom from government censorship is fundamental to our national ethos, and it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office. You can't limit what people are talking about. This is a good idea, this is a bad idea. And one area where this is most keenly protected is political campaigns. That's where we're having the most debate. And of course, the Democrats don't want that to happen. They don't want Trump even to be on the ballot. Tossing these foundational principles aside, which, you know, without going off on a tangent here, but I mean, they are undermining this not only in Trump's case, but across the entire country. And I couldn't agree with this more, that it is wrecking the country that we don't have free speech, government censorship, whether it's Elvis Chan, FBI, Homeland Security, White House staff, whatever. But setting that aside, tossing these foundational principles aside, the Joe Biden administration charged President Trump, the leading contender in the 2024 presidential election, for statements he made as president. That's why he has been charged with crimes. Now, keenly aware sure that Biden is losing that race for this next election in 2024, Jack Smith and Joe Biden's prosecutors seek now to unconstitutionally silence President Trump, but not President Biden's political speech on the pain of contempt. In other words, if Trump breaks the rule and says something about a political campaign that the government doesn't like, he can be sanctioned for that. Joe Biden, though, not, even though it's his DOJ that is bringing the charges. So in support, the prosecution, in justifying this silencing, Jack Smith presents nothing but pretext, Judge, claiming that the court must muzzle President Trump to ensure the following. One, that the prosecution, Jack Smith, and the court and the witnesses are not, quote, intimidated by political criticism. They're going to be so intimidated because Trump is saying things, defending himself against an unjust prosecution. And two, the DC citizenry, this is Jack Smith's justification, who voted by a margin of about 95% for Joe Biden in 2020, do not magically transform and become biased in President Trump's favor, in italics, right? Saying they're concerned, the 95% voting bloc for Joe, that they might turn like 95% for Trump or something. Kind of nuts. That's obviously not going to happen. The prosecution does not present, says Trump's defense, not one shred of evidence to demonstrate either of these claims, let alone enough to establish a clear and present danger to the administration of justice. Neither Jack Smith nor this court, Judge Chutkan, are reluctant to proceed with this case, and none of the public figures that Jack Smith references in its motion have refused to participate either. Everybody's moving forward. You guys are moving quickly, moving right ahead. Nobody is afraid to participate. Just the opposite. Actually, it appears that individuals appear to relish the notoriety that they've gained through this thing. They're all writing books about it. They're all talking about their experiences. They're appearing for interviews with national media. They're even running for president in their own right, talking garbage on the campaign trail. Similarly, despite repeatedly claiming that President Trump's statements threaten, quote, the impartiality of the veneer, the prosecution does not identify a single potential juror who has allegedly become partial against the government due to Trump's statements. So has anybody actually flipped Jack Smith? Like, were you interviewing people and they're like, oh my gosh, you know, I hated Donald Trump, but then I read one of his truth socials and now I'm like, I love the guy. Now I'm going to vote against you. Sorry, Jack. Like Jack Smith's office is waking up with prosecutors now on Team Trump. They're coming into the office with MAGA hats on or something. What the heck's going on there, Bill? Sorry, I was on Truth Social last night. Oh, this is a problem. It's ridiculous. So they get to talk, but Donald Trump doesn't. These people can run for president, but he doesn't get to speak about it. Worse, says Trump's defense, the proposed gag order lacks any semblance of narrow tailoring, sweeping in, for instance, all disparaging statements against any potential witness. So how do you define disparaging in the gag order? They say you can't say anything disparaging. What does that mean? And a potential witness? What is that, like the United States of America? How big is that list? Regardless of the subject, for whatever they want, and also including individuals who are actively waging political campaigns against Trump. So they get to comment to him and he can't comment back. Are you guys crazy? And it does so in a unilateral way. It prevents Trump from defending himself in the political arena, while Joe Biden and his surrogates, including those in the corporate media, of which there are many, have free reign to say whatever they want. Trump gets muzzled, they get a microphone. All for no legitimate reason. The purported goals of this so-called gag order would not be served by the order itself. The media would still feature this case. The media is not going to shut up about it. And the prosecutors and the court and other potential witnesses would still be criticized in the public arena. Like, that's not going to stop anything. We're still doing this show. Trump might not be talking about it on True Social if he's gagged, but you better believe we're doubling down here if he's gagged. And so is everybody else, right? We're going to turn the volume up and say, how dare you silence him and take away his First Amendment right to be able to speak during a campaign? The response will be louder than ever. So the prosecution, therefore, cannot come close to eliminating the exact source of the evil that it purportedly seeks to remedy. It's not really about protecting the prosecution or stopping the jurors. It's about using the criminal courts and the justice system as a tool to leverage it against their political opponents. How much better would it be if Trump is not only banned from Twitter, even though he's not anymore, but he's also now banned from speaking in all of public life? At the bottom, the proposed gag order, says the defense, is nothing more than an obvious attempt by Biden to unlawfully silence its most prominent political opponent, who has now taken a commanding lead in the polls. This very motion indeed came on the heels of adverse polling for Joe. His administration's plan is quite simple. Unleash a 45-page speaking indictment filled with garbage, discuss and leak its talking points to the press, which they've done many times, and then cynically attempt to invoke the court's authority to stop Trump and those acting on his behalf from presenting his side of the story to the American people in the middle of a political campaign. This desperate effort at censorship by Joe is unconstitutional unconstitutional on its face. Here's the law, Judge. They say, even among First Amendment claims, when this comes up, gag orders warrant a most rigorous form of review. Why? Because they set right at the intersection, right in the middle of two disfavored and presumptively unconstitutional forms of expressive limitations. Prior restraints, okay, you're stopping somebody before they say anything, which is a gag, right? That is limiting your ability to speak. And our ability to reason and have a conscious thought and translate those thoughts into our speech is the essence of being human. And so when you try to restrain somebody from speaking before they say anything, that is an egregious violation of a person's natural rights, which are embedded and intertwined into the Constitution. That's why we have it there as the First Amendment. And similarly, also content-based restrictions. So in other words, if you're pro-choice, you get to speak, but if you're pro-life, you don't get to speak. Something like that. Okay, here's a microphone for the pro-choicers. Here is the gulags for the pro-lifers, theoretically, right? One example. Now, in light of these twin presumptions, that would obviously be unconstitutional. Gag orders must survive the highest level of scrutiny. And when we talk about constitutional law, they're citing this guy, Erwin Chemerinsky, who, by the way, is no righty of any way, shape, or form, okay? The guy is a constitutional scholar. I studied out of his law book. It's like this thick, and his companion book is about the same size, okay? So he wrote the textbook on the Constitution, and then he wrote a companion piece, which is about the same size. Very smart guy, very lefty, but he says gag orders must survive strict scrutiny. And in the constitutional framework, that is the most serious standard. Like, it means basically the government cannot do that thing because it's infringing on a protected right, a constitutional right, and the way that it is framed, it has to survive the strictest of standards in order to be constitutional. They say here, this is what it requires. Strict scrutiny requires that prosecutors in a gag order must prove that the restriction is, quote, narrowly tailored to serve a compelling state interest. This is basically the strict scrutiny standard. Prosecutors must meet both standards because if not, there's a real concern that public officials might be prohibiting the speech merely because they just disapprove of the speaker's view. We just don't like Trump, okay? He's Trump and he's going to take away our uniparty rule and stop endless wars and all the things. So they don't approve of that statement, so he is now censored. Now, in the context of pending litigation, the defense says prosecutors can only establish, right, very limited, a compelling state interest, meaning the government has a really good reason for wanting this. If the government's like, well, we think that, it's kind of important because it might make our morning breakfast taste better. You say, well, that's not a really good reason. Okay, it's a bad reason. Or they came out with a different reason, right? They said, no, this is going to impact the administration of justice. Or they said something like, well, we just think that Trump is a bad person. You say, well, obviously that's not a compelling interest. That one's obvious. But they're going to have to prove compelling in this case. And what that means is it is a clear and present danger to the administration of justice. It requires far more than just speculation. The prosecution must proffer the solidity of evidence proving that danger is not just remote or even probable. It's got to be much worse than that. It has to immediately imperil the administration of justice. We've got to get it now. And so here, the Supreme Court has rejected the argument of out-of-court comments about pending cases, saying that they may be censored. It rejects that argument, saying they're giving us a bunch of rules, so we're fast-forwarding through the rules. Now, I generally will just give us a brief touch on the rules, and then they flesh out the rules, and we fast-forward. You see, a lot of these are quotes, and so we're just skipping over it. Then we get to the argument. Now that the rules have been established, and we know that strict scrutiny, the highest standard, must be met, Trump's defense says, guess what? It is not met. Trump's posts do not endanger the administration of justice. Jack Smith and his whiny prosecutors, in their motion, they complain that Trump's political statements, quote, undermine the confidence in the criminal justice system. Let me just give you a little insider info here. Nobody has confidence in the criminal justice system run by Jack Smith, okay, or Merrick Garland, except the left. But you need both sides in a justice system to believe in it. If only one side believes in the justice system, there is no confidence in the criminal justice system. They say that Trump's statements undermine it, and therefore it justifies the gag order. Should everybody be gagged? I mean, we're here every day undermining the competence and the confidence of the criminal justice system because it's incompetent. Jack Smith cites no authority in this support of this bizarre claim, nor can it, obviously. As the Supreme Court has repeatedly emphasized, speech critical of the exercise of the government's power lies at the very center of the First Amendment. That's why we have it. That's why it's the first one. Trump has every right to criticize an unjust government, and this unjust government just happens to be prosecuting him. Here's another case referencing New York Times versus Sullivan, saying criticism of a official conduct does not lose its constitutional protection merely because it's effective criticism, and therefore it diminishes the official reputations. That's the point. It is to lampoon and ridicule these people. They hold the power, they have the FBI, they've got the budgets, so we have our speech. We have to criticize and condemn them for being monstrous and prosecuting according to double standards that serve their own ends. That is the whole point of it. This includes criticism of the court. That's the whole point. The judicial system in particular plays a vital part in the democratic state, and the public has a legitimate interest in their operations. It would be difficult to single out any aspect of government of higher concern than the manner in which criminal trials are conducted. Public awareness and criticism have even greater importance, whereas here, the criticism questions the judgment of an elected public prosecutor. Now, Jack Smith is not elected. He was appointed by Merrick Garland. Joe Biden appointed Merrick Garland, and Joe Biden was elected. Our system grants prosecutors vast discretion at all stages of the criminal process, but the public has an interest in its responsible exercise. And they argue. They say the prosecution in this case, Jack Smith, would silence President Trump in the middle of a political campaign where his right to criticize the government at its zenith, at its highest point, maximum power, all to avoid a public rebuke of this prosecution. They're going to gag him. They're going to strip away the most treasured right because the prosecution's offended. They say here, though, above all else, the First Amendment means that government has no power to restrict expression because of its content, because of its message. And so Jack Smith may not like Trump's entirely valid criticisms. I'm glad they pointed that out for us. But neither it nor this court or the filter for what the public may hear. Instead, the First Amendment, the whole purpose of it, is to foreclose public authority from assuming a guardianship of the public mind. We don't need our elected bureaucrats to coddle us and to tell us what is actual legitimate information, what is disinformation, and all the things. But that's what they're doing now. At one point, we used to, the courts used to really adhere to this. We don't need to be coddled. They wrote this back in 1988. In this field, every person must be his own watchman for the truth. Come to your own conclusions. Create your own explanations for what you're watching. Don't trust anybody on the other side of the screen. Come to your own conclusions, because our forefathers did not trust any government to separate the true from the false for us. Never. Because they're all self-interested for their own personal gain. And we need to know better and think for ourselves. It says, if the marketplace of ideas, they wrote this from the U.S. Supreme Court back in 1980. If the marketplace of ideas is to remain free and open, governments must not be allowed to choose which issues are worth discussing or debating. They can't decide for us. COVID, trust the science, we've decided for you. Ukraine is the most important thing in the world for all of us because we've decided for you. Don't talk about it. To allow a government the choice of permissible subjects for public debate would be to allow the government to control the search for truth. So if the prosecution, Jack Smith, and these people who are bringing this, if they want to avoid criticism for abusing its power, the solution is pretty simple here. Guess what, guys? Stop abusing its power. Just stop it. We think that you're illegitimate because you're abusing your power and you're asking for more abuse. Now to dump on the First Amendment? The Constitution allows no alternative. It's pretty simple. If you want people to think the DOJ is legitimate, act like a legitimate institution. Now they've got a couple footnotes here. They say, no one can doubt that substantial segments of the public harbor deep suspicions about Jack Smith's motives in this case. It's Merrick Garland's and it's Joe Biden's, and let's be real, it's the DNC's. President Trump has a constitutional right to speak on this subject, both as a candidate and as a citizen. They say, there is no alternative. There cannot be a gag. The prosecution here utterly fails to establish that any confidence at all in this process, like quantifiably, has been lost due to President Trump's statements. They haven't measured the impact, and they haven't been able to show us that if he's censored, it's going to restore the confidence. Like if Trump is censored, is everybody going to go, oh yeah, Jack Smith and Joe Biden are all legitimate again? No, obviously not. It cites no statistics. It has no affidavits. It doesn't even explain how many people have seen his comments. So to satisfy strict scrutiny, that high standard, it can't be speculative or assumed. It has to be in evidence. And the prosecution have not done that. Trump's defense continues. They say, Your Honor, now Jack Smith and the prosecutors argue without evidence that they need a gag order to stop the, quote, intimidation of the prosecution and their, quote, potential witnesses. They say this claim is meritless. First, it is absurd to suggest that Jack Smith and the court are, quote, intimidated by social media posts. Absurd. Let alone to such an extent that it presents a clear and present danger to justice. They don't point to a single prosecutorial or judicial function that has been actually impaired due to the posts, or how they would be unable to fulfill our duties. Is Jack Smith cowering in a closet somewhere, shaking? Trump's posting mean truths. I can't get to my office and buy my $5 footlong, or whatever they cost now. now. Every hearing in this case has gone forward on schedule. There's been no incidents. There is zero reason to believe that any of that is going to change due to President Trump's political expressions. Similarly, no witness has suggested that he or she will not testify because of anything Trump has said. In fact, witnesses are eager, and they're undoubtedly going to be testifying if called to do so. It's going to be a media circus. You guys have made sure of that. This is entirely unsurprising. President Trump has never called for any improper or unlawful action. Quite the opposite. In fact, Trump's posts that were even cited by the prosecution show that President Trump intends to redress the unfairness of this proceeding through legitimate means. Yeah, he's going to win the presidency. And then all the stuff he says about repercussions coming, guess what? It's all going to be legitimate. He's just going to do the same stuff that you guys are doing. This includes, for example, filing motions with the court, a form of relief that President Trump has every right to do. Filing motions is a far cry from a, quote, true threat that would scare Jack Smith. So when they are unable to identify any instance where President Trump uttered any actual threat, the prosecution points to other people. They say, well, other people are reading his truths and they're posting mean stuff. They say that Trump knows that when he publicly attacks individuals, he inspires others to perpetuate the threats and the harassment. So Trump can't post anything that might cause somebody else to post something, which is basically anything. Again, the prosecution offers no evidence there's any causal connection between his speech and the other allegations of unlawful acts. Regardless, though, it goes without saying that the Constitution does not permit President Trump to be censored for the unprovoked acts of third parties. No such acts can allege a prior restraint of Trump, because what kind of an insane rule would that be? If you say something and anybody does anything bad as a result of what you said, you're now censored from speaking. That's what the left is basically arguing here. Jack Smith. The prosecution does not and cannot explain how Trump's statements would provoke any reasonable listener to lawless or otherwise fighting words type behavior. They are core protected speech if they are not a true threat. Again, they're saying, Your Honor, the First Amendment requires more than what Jack Smith is giving you. Judge Chutkan. Bare speculation that somebody might interact with Trump's comments is not enough. We need evidence that Trump's statements would immediately imperil the administration of justice. There needs to be a causal link between the alleged speech and the harm. Prosecution hasn't proven any of it. But even if they could meet this test by identifying some threat under the Brandenburg standard, it emphatically cannot and would only justify a very narrow restriction, not what the government is asking for. They want Trump to be gagged on all disparaging statements and all, quote, potential witnesses, and certainly not at all even comment on the case. And saying, finally, Your Honor, the prosecution bemoans the disparaging messages directed to it, but they ignore the equal amount of vitriol directed to the defense. Oh, Trump receives harassing messages by phone or email nearly every day. Others associated with Trump receive the same treatment. Yet the prosecution seeks only to bar Trump from speaking. These inequitable restrictions offend the First Amendment on their face and have no place in our jurisprudence. And now they move on to subsection B, and you can see this is where they're going to talk about the jury. So now Jack Smith is saying, Your Honor, his mean truths could affect potential jurors and the impartiality of the 95% Democrat jury pool in Washington, D.C. But they failed to explain how that might happen. In their view, Jack Smith says President Trump simply talking about a witness who might be a public critic, an author, or a political opponent, just that act of talking would prejudice the jury through improper bolstering or impeachment. That's their allegation. Trump's defense says, Judge, that is not the law, and no authority permits a blanket gag order that's going to limit his First Amendment rights because they don't want the jury to hear it. To promote impartiality, they say the defense says that they could use other tools short of gag orders, right? You don't need to gag Trump. Just get a bigger jury pool, go through voir dire, change the location or the schedule, create jury instructions, or sequestration if you need to. But the First Amendment is not the right avenue. Prosecution has not demonstrated why any of these alternatives would be inadequate or why a near complete gag order that would preclude anything like this is appropriate. And so they're going back to the strict scrutiny standard. It's necessary and it is the least restrictive means. Like the government has no alternatives at hand. Yes, they're going to dump on your constitutional rights, but they have to, okay? There is literally no alternative. It's extremely compelling and there's nothing else we can do. Trump's people are saying there's a ton of other things you can do here. Look at all this stuff. You can go, you can here have jury instructions, do voir dire, just ask him questions. Did you hear Trump's truths when the jury comes in, right? They keep telling us that if the jurors hate Trump, that they can fix that. They can say, well, can you set that aside and still be fair and impartial? And the jurors say, yes, I can. They go, perfect. I get what you're saying there. there. And so they say, I'll set all of that aside. So Jack Smith, couldn't the jurors set aside anything that they saw? Here, this is insufficient, says Trump's defense. Jack Smith cannot claim that the gag order is narrowly tailored. It must prove that it is literally the least restrictive method and that there is no other alternative that would suffice, and he's not even close on this one. So the question, therefore, is not whether the case has garnered public attention or whether the public could see bad information. The question is whether the judge finds it likely that he or she will be unable to guide a jury to a verdict. If they can, then no gag order may issue. That's from a prior case. Here, Trump's team says that Jack Smith has not pointed to any statements by Trump that present a danger that would justify him of his First Amendment rights. The speaking indictment, as part of an obvious strategy, launched false and derogatory public accusations against President Trump, which the prosecution then expanded with gratuitous out-of-court statements wrongly insinuating that Trump was responsible for J6, an allegation that wasn't even made in the indictment. So in this respect, Jack Smith and his media allies, they represent a far greater threat of prejudice to the veneer of justice than anything Trump has done, right? They're blaming Trump for an insurrection every day, insurrection, not been charged with that. President Trump and his counsel and his agents have a right to counter this harmful publicity with their own response. Such efforts, if he's limited, would stop him. And him being able to speak does not prejudice these proceedings. In fact, it protects President Trump's rights under free speech. So this entire argument about jury influence to justify the gag order, they're not able to show that there is no alternative. They failed to meet this burden. Therefore, it is unconstitutional. And then the last main section of this is talking about the gag order not being narrowly tailored. Like the gag order itself is just way overbroad. They give us some rules. They say that here, the proposed gag order does not meet the rules. It is sweepingly broad. Many of its terms are undefined. We don't even know what it means. For example, Jack Smith proposes that President Trump and his attorneys be restricted from, quote, making or, quote, authorizing any statements that pose a substantial likelihood of, quote, material prejudice. So whatever that is. Now, this is not only the wrong standard, but it's vague. It provides no settled boundaries with classic terms of degree, and President Trump is just left to guess. So he can't really speak because he might say something that is, quote, substantial or, quote, material, despite obvious disagreement on both of those things mean. Determining whether a single statement meets that standard is very difficult, and we're going to fight over how to resolve that. So to make Trump come to that conclusion in real time every time he speaks is just utterly intolerable. Let's be clear, says Trump's defense. Jack Smith hopes to create a contempt trap for President Trump and his attorneys. So they create this amorphous blob of limitations. Then Trump says something and they say, substantial, material, sanction him, contempt. Although the prosecution offers some examples of conduct that it would consider prohibited, it also cautions that the examples are non-exhaustive. And many of these examples are intentionally vague and they're created to chill President Trump's First Amendment rights. Here's one example. They say Trump would be prohibited from making any statement about the identity, the testimony, or the credibility of prospective witnesses. We don't know who is a prospective witness, no list. We don't even define what prospective is. Don't even know if it's like somebody that Jack Smith dreamed about that one time. That group could include anyone who worked in the federal government around J6, anyone who was involved in a state election. And further, that broad characterization of prospective still does not include everyone that they could claim as a prospective witness. It could arguably be Trump's political rivals in the upcoming election. And therefore, Trump could be at risk of contempt every time he talks about someone who's relevant to the political campaign. Plainly unconstitutional, and they say it needs to go. Another example that came from Jack Smith, Trump should be prohibited from making disparaging and inflammatory or intimidating statements. Again, whatever that means. Everything Trump says, according to Jack Smith and people on the left, is each one of those things. Trump says, I had a great lunch today. They're like, oh, where did he eat? Probably a white supremacist sandwich or something, huh? I'm intimidated. Trump likes lunch. Oh, yeah. What about the one meal a day, people? I'm sure Trump has lunch. That's very nice of Trump to have lunch. What a bigot. Now, regarding another wide and defined set of individuals, don't even know what those mean. The government does not define those adjectives, but by its content of its motion, it appears that it would include speech far below anything that is a clear and present danger. The only speech the government appears willing to permit are basic case information communicated without comment, but none of the cases that they cited allow this to happen. Comment is at the very core of the First Amendment. They say here, as stated, Your Honor, the proposed gag order is entirely disconnected from the harms that the government says are happening. If they're saying things are bad, this doesn't solve the bad things. They make no attempt to minimize the consequences this would have on his First Amendment rights, and therefore this is unconstitutionally overbroad and fails the constitutional muster. Now, little of this from Jack Smith's office is devoted to Trump's speech. In support, they cite comments made by Trump's co-lead counsel in their indictment. Without question, the misleading allegations in the indictment have been made to skew public opinion against Trump in this historic case. And special counsel's out-of-court statements have the same effect. The rules say prosecutors should not make extrajudicial comments when they're outside of the courtroom. But here, in this case, Jack Smith, Joe Biden, and the DOJ, they have engineered negative press towards President Trump, and now they want to silence his lawyers too. Under settled law, counsel has the right to counter this false narrative with statements of their own. And so stop trying to silence the lawyers. As recognized by the Supreme Court, public debate about a criminal case almost always skews in favor of the prosecution. Talking about general public awareness, by prohibiting information, a gag order can actually distort the discussion and prejudice the case rather than mitigating it, which I think is exactly what we'd do here. If Trump can't talk about it, it's just going to be more evidence that this whole thing is illegitimate. Like, they're going to make their own argument worse. The fact that they're trying to even gag him in the first place, I think, is hurting them, but the consequence is already in motion, I would say. Thus, both this court and the disciplinary rules cannot punish activity protected by the First Amendment. So the lawyers can speak about this stuff, and your attempts to stop them from communicating about it are not appropriate at all. Every statement that Trump's lawyers have made in this matter have been appropriate under applicable law and in response to the prejudicial environment that was created by Jack Smith and their team. Here, President Trump's attorneys cannot adequately and ethically defend him and assure him a fair trial without responding to these comments. We've met every obligation under the bar rules and don't restrict our speech. And finally, we don't want Trump to have to get permission to do anything in this case. They want Trump to come here and seek permission prior to doing polling of juries, to doing jury studies, and obviously that is just ridiculous. And so they say that the government has not articulated any basis for overcoming any of this. We already know the cases in Washington, D.C. We know the case does not favor President Trump. Any restrictions on pretrial polling would only work to further disadvantage the defense, which has a right to prepare for trial without interference. And so, accordingly, Your Honor, long filing, blasting Jack Smith, the court should deny the motion in its entirety. Do not grant any gag order or any protective order, any limitations at all. Given the significant First Amendment issues presented by the motion, we ask that the court schedule a hearing at the first opportunity on this case. Signed and submitted September 25th, 2023, Greg Singer, John Lauro, and Todd Blanche on behalf of Donald Trump. Good filing. I think absolutely reprehensible that Jack Smith is even attempting this. But again, it's not about justice. The process is the penalty. They want to get him convicted with any type of felony, doesn't matter, so that they can make arguments that he's already been insurrected and convicted and keep him off the ballots. Any conviction will be useful in 14th Amendment litigation going on around the country, and it will also be useful in their media onslaught when they can say that president has been convicted. And so obviously Trump should be allowed to defend himself. This is the First Amendment. The fact that the government is prosecuting him doesn't mean that your ability to speak just suddenly goes away, does it? That's what they would want, because they're censors, they're bullies, they're cheaters. What they try to do is just take their opponents off the field so that they can win, because that's how they like to play. But this is a great motion. Of course, there will be a reply from Jack Smith to this motion, and then we'll get a ruling from Judge Chutkan. When we get it, we'll continue to cover it, my friends. I hope you join us and subscribe. Share this video with anybody that you think might enjoy some of the stuff we do here. We'd love to see you back here on the next one. Don't forget to check out robertgovea.com and sign up for our daily newsletter so you get all stories like this delivered right to your inbox, and we'll see you on the next one.